I'll just note for the record that although we have allocated 20 minutes to a side, if we are asking questions, please continue to respond. You need not ask permission to do so. It may mean at the end of the day one party has more time than the other. It's simply a function of how many questions we have of your issues, not a reflection of how we view the merits of your case. Now, once you've settled, I'll ask for counsel's appearances.
Emily Adams for the appellant, Danielle Kracht.
Ms. Adams?
Alexandra Marshall for the appellant father.
Ms. Marshall, good to have you both with us.
Taylor Webb on behalf of appellees.
Welcome, Ms. Webb. Let's begin. Oh, I should note also for the record that Justice Nielsen is appearing virtually today.
Good morning, Your Honors. This morning, I'm going to argue on behalf of both Mr. and Mrs. Kracht. Okay, this case represents a straightforward question of whether the strictly necessary analysis applies when a termination is through the Adoption Act. We awkwardly have already kind of talked about this, and so I will just briefly restate where we're going and then just add a few more arguments on top of that. As we talked about before, the Adoption Act incorporates the grounds as described in the Termination Act, and that incorporation brings in the substance of the grounds of the Termination Act. And when you look at the Termination Act itself, under the termination statute, you have a large modifying clause that begins subsection 1, and it's followed by a list of circumstances where termination can occur. Both the modifying clause and the list of circumstances are grounds. Although this court has created an analytical framework that separates the two, when we look at the statute itself, it's both best interest and grounds that describe the quote-unquote grounds as described in the Termination Act. Now, the other side has argued that it doesn't make sense that the Termination Act would incorporate the Adoption Act because there would be so many provisions of the Termination Act that don't apply in private adoption cases. But as we cited, the case at Navarez, which is that 2015 Utah 34 case, we look at exactly what is the act incorporating. And here it's the grounds described. So we're not incorporating, for example, the reunification efforts provisions. We're not incorporating everything else in the Termination Act. We're just incorporating the grounds described in the Termination Act.
And you read that as being all of 301?
We read that as being...
Or just 301 subsection 1?
301 subsection 1. Now, of course, there is a subsection further down that describes what strictly necessary in the best interest is. So, of course, that would be incorporated because it's a definition. But yes, it would just be 301 subsection 1. Perhaps the interpreting the Adoption Act as incorporating the whole of subsection 1 as the grounds does not render any language in the Adoption Act superfluous. After mentioning the parental rights can be terminated on the grounds described in the Termination Act, the Adoption Act says, and termination is in the best interest of the minor child. The best way to interpret this phrase is not that it's modifying any substantive requirements of the Termination Act, but it's just redundant language. And this happens all the time. So in our favorite reading law by Scalia and Garner, there's a canon on page 176 to 177. And it says, courts should not apply the surplusage canon rigidly because sometimes drafters do repeat themselves and do include words that add nothing of substance, either out of a flawed sense of style or to engage in the ill-conceived but lamentedly common belt and suspenders approach. The legislature here was just reiterating, like we talked about before, that we have this two-part analytical framework that needs to be applied. Interestingly enough, the legislature seems to do this redundant drafting in child welfare statutes. So if we look back at 301, when it's listing all the circumstances that can lead to termination of parental rights, there are two circumstances that say best interests, that add a best interest, which wouldn't make sense because we already have best interests up top in the modifying phrase. Those are if a parent is convicted of a sexual offense and if a parent voluntarily relinquishes. And interestingly enough, this voluntary, the sexual offense language was added quite recently. So the legislature seems to just be putting in this redundant drafting to make sure that the parties understand that you have to do this full analysis.
I'm sorry for such a basic question, but I want to make sure that I'm looking at the right version of the statute.
I think that's an
Are we
excellent
talking about the one in effect on, in terms of the Termination Act, 301, 2023?
So we've used the most recent one. It's the one after, let's see. It
Okay.
was amended, I believe, in 2024 also.
Okay,
So,
that's why I'm off.
so, yes, I apologize, Your Honor. So we're adding, I think we can just use, even though this happened a while ago, I think we can just use the statutes as they stand today. They've been amended multiple times over the past 10 years, and so I think we can use the current statutes because the substantive grounds have remained the same.
I think that the introductory language in subsection, that starts out subsection 1 has changed, though.
It has changed,
I
but
don't think it used to say best interests.
so the best interest language was added in 2012. So was from the child's point of view was added in 2020, and then I believe it was added in 2024. Best interest was added in 2024. Yes, Your Honor. And then an entire section on what strictly necessary in the best interest of the child was also added in 2024.
So are you looking at, I was having a hard time finding this too, because it used to be 78.6.1, which isn't there anymore, and then it looks like it's now in Title 81. So are you looking at the Title 81
Looking
code?
at the
Or-
the Title 81, so it's 81-13-205.
Okay.
So I think it's helpful. I apologize, I should have done this from the very start. So we're looking at 80-4-301 for the Termination Act and 81-13-205 for the Adoption Act. And the language in the Adoption Act has been tweaked a little bit, but it's stayed essentially the same for the last few years. Anyway, the legislature appears to do this redundant drafting, as we talked about with Justice Pullman before. Certainly, it's hard to read the legislative tea leaves. It seems like the legislature was maybe just incorporating in re TH when it added this in best interest back in 2012. Certainly, it wasn't responding to the amendment, the addition of strictly necessary in 2012 to the Termination Act, because it didn't say best interests in the Termination Act, and that strictly necessary prong wasn't tied to best interests until about 8 years later, when the Court of Appeals came out with BTB. But certainly, you could say that the legislature has had many opportunities to ensure that strictly necessary doesn't apply. It hasn't taken those opportunities. And it seems like the legislature, instead of trying to accept out strictly necessary, is instead just engaging in redundant drafting to ensure that we are engaging the appropriate analysis to terminate fundamental parental rights.
All right, let me just make sure I understand that. The redundant drafting is hard for me because if that's really their intent, then I would think they would put strictly necessary in there too. So if we're going to say that's why that's there, is to make sure we follow it, why aren't they also putting strictly necessary in the adoption statute to make sure it also is being applied in that context?
So when they did this back in 2023, the strictly necessary was in the grounds, I think could have been interpreted to just be part of the grounds, right? And not a separate part of or not an additional part of the best interest analysis. So the fact is that strictly necessary was never tied to best interests until 2018. And so in 2012, when the Adoption Act was amended to add the phrase best interest, there certainly wasn't an indication that strictly necessary was part of best interest, or that putting best interests in would mean that it was getting rid of strictly necessary. It just seems, Your Honor, like these two statutes were amended on separate tracks and weren't really talking to each other.
That might be true. I mean, they were done on the
It's
same
possible.
day, right? And they've both been amended multiple times since
Yes.
all of the strictly necessary
Yes.
case law has come into play.
Yeah.
So it's a little bit hard for me. I mean, it's hard for me to really read too much into any of it because I think it can go both ways. So I tend to just resort then to the plain language. And at least when I just read this, the very first time I read the brief, I think of what are grounds. I know what grounds are. Those are the reasons, that the parent might have its rights terminated, right? I don't think of it then as this additional question as to whether termination is strictly necessary. I've already established grounds. I mean, I just see those as different things from the plain language. So
Yes,
I don't know what I'm really saying there, other than it's really hard for me to really assess their intent from all of these back and forths, because I feel like depending on which lens you look at it through, it could go either way.
Yes, Your Honor, we can make good arguments on both sides.
Okay.
It's great legislative history work for us. Law students will love it in the future.
Right, it is a great law student question.
Yeah, it's a very last question. But I do think when we get to grounds, it's very telling that although the court is saying grounds, the legislature is saying grounds, it's very telling that in the ground statute, it includes strictly necessary and in the best interest.
That's fair.
So the legislature seems to be thinking about this quite differently than the courts have been thinking about it as a two-step framework for quite a while. And as we argue at length in our brief, if this court believes that it just means grounds and you don't have to apply strictly necessary, then we have the absurdity doctrine that applies, the absurd consequences doctrine. And also, I think we run headlong into the canon of constitutional avoidance. I think the brief could have been drafted a little bit better. Very clearly, when we raise our uniform operation of laws and our fundamental rights arguments, those are all in the context of the canon of constitutional avoidance. We are not saying that the Adoption Act is unconstitutional. What we're saying is that if this court interprets it in the way that the appellees would like this court to interpret it, then it is unconstitutional. So it's just simply a canon of canon of interpretation that we are employing here.
I have sorry, go ahead, Chief, please.
So I suppose that you could read that prefatory language in a couple of ways. One is that strictly necessary informs or qualifies each of the grounds below. Or you could find that a finding of strictly necessary being required to terminate itself qualifies as a ground. Could you respond to that?
I think the court discussed this back in BTB, back in 2020, when it was deciding where strictly necessary fit in the analytical framework. And the Court of Appeals and then this court determined that even though when it was first amended, it was strictly necessary and it didn't point to anything, that it made the most sense to have it be strictly necessary in the best interests of the child. We're not arguing, Your Honor, that we should be messing with the two-part analytical framework. I think it works. No, I don't think anybody here has argued that it should be overturned. But I think it's important to distinguish between the two-part framework that we have and the way that the statute is actually drafted, which seems to squish everything together.
I have a question about the difference between the Section 301 that was in effect at the time this decision was made and the current one. Because there does seem to be one difference, is that if I'm looking at the correct thing, in 2023, it didn't refer to best interests in subsection 1 of the grounds. It just said, from the child's point of view, is strictly necessary. And then they added, from the child's point of view, is strictly necessary to promote the child's best interests. I'm wondering if that just makes any difference here, or maybe explains why the Adoption Act refers to best interests specifically, but not just strictly necessary. Do you see any, can we read anything from those tea leaves?
I don't think we can, Your Honor.
Okay.
I think the fact that this court interpreted strictly necessary back in 2020 to be part of the best interests, I think that what the 2024 amendments were doing was codifying BTB, partially because the GAL was trying to overturn BTB many, many times between the time BTB was released in 2020 and even until just recently last year in In-Rate DS. And so I think this was an attempt to just make sure that BTB was codified, and that's why we also have another subsection at the end which defines what strictly necessary in the child's best interest is, and it essentially codifies what BTB says. So I think the only thing we can read into it is that it was simply codifying BTB to kind of hold off some of these challenges to BTB from other offices.
And that all of these references, like the reference back to 80-4-104, which already has strictly necessary and best interests, and then the repeating best interests here in 301, and then repeating best interests again in the Adoption Act, that those are just redundant, that we don't draw any meaning from. Those are just redundant references for emphasis, perhaps.
I think the most generous way of looking at it is that it's redundant drafting, because these are fundamental parental rights, and the legislature is very concerned about terminating fundamental parental rights prematurely. So I think the legislature is just repeating this stuff, although maybe unnecessarily, just to emphasize that we want to make sure that we are terminating these fundamental parental rights in only the circumstances where it is necessary. Your Honors, we have gone through the constitutional canons, but unless this court has any other questions.
Let me just ask you,
Yes.
I think an argument was made that the constitutional argument wasn't preserved. And I understand the distinction you're making in saying we're not challenging the constitutionality of the act. But it does seem to me that if someone is claiming that this creates a constitutional issue and here are the provisions it would create it under, that would make a lot of sense to present that to a district court and let the district court weigh in on that and think about that as it's applying the act. So I'm trying to figure out why we wouldn't decide that that's not preserved in this case.
Your Honor, I think that there certainly were some hints about constitutionality in the district court when they were arguing about this, but really it just becomes straight up. We're not saying that the statute is unconstitutional. We're not going there at all. It simply is a canon of interpretation. And under Garcia, and I believe...
Let me just stop. Isn't the suggestion that it would be unconstitutional, though, if we interpreted it that way? So it's not just that it creates constitutional concerns in the sense that rights are implicated. I think you're pointing to specific provisions and saying if we interpreted it the way that, that the grandparents are suggesting, that it would render the act unconstitutional, right? Or at least that provision of the act.
Right. When we come to interpreting statutes, this court has an obligation to get it right. And in BTB, this court said that parties cannot force a court into a strained interpretation of a statute by the arguments they advance. The court's duty is to get the law right, and parties cannot push us off this path. So you can't, and then the court goes on and says that we can, a party cannot prevent a court from employing certain canons of construction by failing to argue them. So here, certainly, Your Honor, should the constitutional stuff have been raised below? Should we probably have raised an exception? Probably. But really, this court has the obligation to get the law right and to interpret these statutes correctly. And the fact that we have two cases up here on the same day involving the same question means that it needs to be interpreted correctly. And if this court were to interpret it in a way that would cause constitutional concerns, the canon of constitutional avoidance is a completely appropriate canon for this court to consider. And this court should consider it. Notably, that we have also raised the absurdity canon, which does not need to be preserved. So we have given this court lots of paths that can take to get to the solution that we would prefer.
I have one more statutory
Yes.
question. So does the language in the Adoption Act incorporate all of 84-104?
I would say yes-ish. So it certainly incorporates.
Yes-ish.
Yes, it incorporates the grounds.
I was kind of thinking yes-ish because some
It
doesn't
is
quite
yes-ish.
fit.
Yes, it really
Yeah.
is. So it incorporates certainly the grounds statute 80-4-301, but then 80-4-301 goes and incorporates. It says, subject to the protections of 80-4-104.
Yeah.
And so I think it does, by extension, you have to look at what these other statutes are referring to. Certainly there are parts of 104 that talk about part of the best interest analysis is looking if there's been an adequate process for reunification. That certainly wouldn't apply in this context because there are no state protections. So I think that's where we get back to perhaps the Navarez case that looks at what is the statute actually getting to, what is it actually incorporating, and we can maybe disregard some of the stuff, of course, about reunification.
And it seems like I'm trying to look back in the Adoption Act where they have what seems like a bit of a counterpart to 104.
Yes,
But
they do.
and I'm not finding specifically where it is, but it's
right.
the spirit of it is different than 104, where 104 is really talking about parental rights and the child's right to be with the biological parents. In the Adoption Act, it's talking about the child's right to be with a stable adoptive placement.
Yes, Your Honor. So there's a pretty significant difference, I think. Certainly, I think that the Adoption Act, if you look at the Adoption Act's...
202, sorry,
There we go,
it's
sorry.
8113, 202, legislative findings,
the
best
legislative
interest of
findings.
the minor child. They come at it from a different angle than 104, and talk about the state's compelling interest in providing a stable and permanent home for a child adoptee and a prompt. So there, the interest that the legislative interest that they seem to be talking about is the child deserves a stable, permanent home with an adoptive family, there needs to be finality, it needs to be done quickly. Whereas in the Termination Act, they're really stressing, look, don't do this until you make sure that you're not violating the parents' rights. So they're coming at it kind of differently in the two statutes, and so I'm not sure how to weigh 104, which is swept in by that language, that kind of the prelude to the grounds in the Termination Act. Yeah. I'm not sure what to do with that.
I have a multifaceted response for you.
Okay.
So first off, if we look at 202, the very first legislative findings, it needs to be in the best interest of the child. So I think that both statutes start with this needs to be in the best interest of the child. And specifically in 104, it talks about how generally it's in the children's best interest to be raised by their natural parents. And there certainly isn't anything here that contradicts that statement. Interestingly, 202 is really focused on unmarried biological parents, and it's really heavily weighted towards unmarried biological fathers. I think there's a real sense in the Adoption Act, and there's more provisions in the Adoption Act for unmarried biological fathers, and what do they have to do to assert their rights, and what do they have to do to protect their rights, and it's very, very strict with timelines. And so the Adoption Act, I think, is more geared, I think when we're looking at 202, it's not like the legislature is making findings that say that it's not appropriate for the children to be raised by their natural parents. I think it's saying in these cases where we have unmarried biological parents, what do we do? And in those instances, it is in the children's best interest to find an adoptive placement quickly and to have a secure and stable environment. Also, when we're looking at two statutes that don't really talk to each other well, probably the best case is Taylor v. Taylor, which was a case that this court released back in 2022. And in that case, the arbitration clause, there was some conflict between the arbitration clause and the divorce code. And Justice Pierce said, well, we've got two statutes that don't seem to talk to each other. So what do we do when that happens? We look at their purposes and we try to harmonize them. And this court looked at the purposes of both of those statutes and realized, yeah, certainly for things like alimony and property, arbitration is completely appropriate. For things like child custody, not so appropriate because the court has to determine the child's best interests. I think if this court wants to go down that road, it certainly could take a Taylor approach and look at the purposes of both of these statutes and realize that they really do harmonize quite well. In the end, we have the Termination Act saying it's in the best interest of the children to be raised by their natural family, and that certainly isn't in any way contradicted by the Adoption Act. And the Adoption Act is just saying if you've got these late filed, these straggler biological parents, they really shouldn't, if they're not asserting their rights timely, then the children need to have a home. And it's simply, the Adoption Act doesn't really address the option that we have here, which is we had married biological parents, and the children were with the married biological parents, one or the other, for several years. And then things kind of fell apart and they ended up with grandparents, but it really doesn't address the situation we have here. Unless this court has any other questions, we'd ask that this court reverse and remand to the district court for a strictly necessary analysis.
Can I, before you, because I want to make sure you can address this so it can be responded to, but I realize the court here didn't use the word strictly necessary. It's completely unclear to me whether he thought he needed to apply that or not. But he did make some, I think, some findings here, and let me just pull this up because I've got them.
Page 260, 682. Is that where we're
Yes,
going?
46H, you knew where I was going.
Yes.
But I mean, he finds that these parents constitute a danger to the health and safety of the children. That's a present,
Yes.
current finding. He also says it finds no benefit and only potential danger to subjecting the children to further contact with them. They have no meaningful relationship and no evidence that an ongoing relationship will benefit the kids. I guess I'm just wondering, I get that he didn't label that strictly necessary, but it does sound to me like even if you considered alternatives, those alternatives would still keep them in their lives and having some control. And it seems like those findings would run straight into an alternative kind of a relationship. So I'm just wondering, even if the court didn't use the words and maybe even didn't think he was applying a strictly necessary test, it seems as though those findings would support a strictly necessary conclusion.
So they actually don't support a strictly necessary analysis as the court has articulated it under BTB. This is what the court says in BTB. It's a paragraph 69. The strictly necessary language is designed to ensure that the court paused long enough to thoughtfully consider the range of available options that could promote the child's welfare and best interests. I think key there is that the court paused long enough to thoughtfully consider the range. And then this court in BTB and most recently in Ray AH 2024 case, this court said you have to explore whether other feasible options exist that could that could address the specific problems or issues facing the family. So here the court jumps right to parents are in danger, we can't do it. But there wasn't any pausing, there wasn't any exploring. And that is what the strictly necessary analysis requires. It requires an on-the-record, thoughtful consideration of other options.
So do you think that that the court actually has to say, I have considered whether a permanent guardianship arrangement would work, and this is why it won't?
I believe that is what BTB and NRAH and all the other cases that have come out do require. They require an on-the-record discussion of why there are no other options that would work to fix the problems that are facing the family.
And saying that the parents, any continued involvement of the parents in their lives doesn't accomplish that?
It doesn't accomplish that in this circumstance, Your Honor, because the children had been in this effective permanent custody and guardianship since 2020. And it had worked. It had worked. The parents were unstable and they were kind of doing their thing, and the children were with grandparents. And the only reason that this this adoption petition was brought was because father got a default divorce decree in June of 2022, and where father got custody of the kids by default. And the court told the parents, or told the grandparents, well, you don't have any legal order, so go do something. And that's when the grandparents filed this. So, in the end, Your Honor, there are things that could be the feasible option is keeping the situation as it is right now. And at least in mother's context, the evidence was that she's calling the kids every month or every other month, and there certainly wasn't any testimony that the kids reacted in a way that was harmful to the kids or that they didn't want the calls. There wasn't any testimony about the children's reactions to those calls. We just have evidence that mother is calling and talking with the kids semi-frequently.
Isn't there evidence that there's a protective order against his contact with them till 2029?
So I believe there is evidence about a protective order. Yes, so I think certainly that would complicate Dad's circumstances.
For sure, right? I mean, how can there be an alternative arrangement if he can't even have contact with them?
Well, certainly there could be a permanent custody and guardianship where then he could contact them when it is appropriate.
Okay.
Great. Thank you, Your Honor.
Thank you, Ms. Adams. Ms. Webb.
May it please the court, Taylor Webb on behalf of appellees. I think that last line of questioning sort of gets at the heart of this, which is that appellants have a pretty steep hurdle to climb here. I guess I'm mixing metaphors there. A steep hill to climb here in terms of there's a few hurdles to them getting to even, for example, the constitutional questions that they've raised. If we have any concerns about, for example, constitutional concerns, we have other ways to avoid them, including the alternative grounds to affirm, and primarily, which this conversation was getting at, is harmless error, the lack of prejudice to the parents in the district court's order having effectively gone through a strictly necessary analysis. So even if this court were to determine that analysis is required, that analysis is already there. And there's no showing by the parents that there's any different analysis that would have led to a different or better outcome for them in this case. In terms of explicitly considering a permanent custody and guardianship I think that the court didn't need to go through the effort of saying I have considered and rejected a permanent custody and guardianship, because that's exactly what the grandparents and the court has observed the grandparents trying to do for several years, and it wasn't working. So the reason that this arrangement sort of worked for the last several years was because the parents were effectively forced to be away from the kids and the grandparents, because the documented history of this case shows that any time that parents had any sort of meaningful involvement with the children or the grandparents, things went downhill very rapidly and very severely, and the grandparents had to clean things up in the wake. So it's not as simple as, the grandparents can maintain the status quo, and so we don't need to do anything. We've tried that several times. We had formal custody arrangements where mom formally transferred temporary custody to the grandparents, and instead of following any of the provisions that she had agreed to and that the court had set out, she kidnapped the kids, never complied with any of the terms that she had agreed to, and when the grandparents were finally able to get the kids back, they were detoxing from methamphetamines. So this is not simply a scenario where the parents are just not in a position to be the primary parents to the children. This is a scenario where every time the parents have contact with the children, things go sideways. The only meaningful contact that the father has had with the children in the last decade, effectively, is when he also kidnapped them for a period of time. And then when grandparents, again, were finally able to get the kids back from the father, they were, again, struggling there was a huge struggle. One of the children has epilepsy, and that epilepsy had been left untreated for the time that father was involved. And I take the point that, those are concerns that are primarily when the kids are in the parents' custody, but we sort of have this evidence that we can't trust the parents to let the grandparents keep custody and let the grandparents do what needs to be done to take care of the children, because anytime they're allowed even the shortest leash to participate in the children's lives, everything goes wrong. Even, we have the statement by father that he would certainly agree to do whatever was necessary to cooperate with the permanent custody and guardianship. But again, we have demonstrated evidence that that is not true. As soon as grandparents take custody of the children, he sends profane text messages accusing them of kidnapping, faulting them for taking care of his children. He is awarded by the court the ability to have this parent time, which is really what he would get if he had residual parental rights. And when he's awarded that parent time, he tests positive for drugs and then doesn't show up and doesn't actually utilize that parent time. And I think that the parent's response to that is effectively, well, if mom and dad are just off in the wind, then there's no harm to the kids. But I think that there's a sort of flaw in that argument too, which is whenever they are around, there are problems. But the fact that they are absenting themselves from the kids' lives is its own problem, and that's one of the district court's findings here, which is the parents' sort of history of addiction has made them absent from the children's lives through being incarcerated, but even in those times where they weren't incarcerated, they were voluntarily absenting themselves from the children's lives, going off and doing whatever they do and leaving the kids wherever they are. So it's not just as simple as, well, these are parents who can't provide stability for the children, so we'll let them kind of handle their business on the side while the grandparents take control. We've tried that many times and it didn't work, and the court's findings get at the heart of that. So the strictly necessary analysis is baked into the court's ruling, and the fact that the words strictly necessary are not in there make fundamentally no difference. There is no showing that if we were to send this back down to the district court and ask him to make strictly necessary findings, that the outcome would be any different, or even that the findings would be any different. And I think that's one of the other hurdles, which is there's somewhat of a preservation point here that obviously that the court has to that the court has to be presented with the opportunity to correct its error, and this is one of the rare circumstances where we do have case law from this court that says that if you think there's something legally insufficient about the district court's findings, that you need to give the court the opportunity to correct that by, for example, filing a post-trial motion, even though that's typically not a prerequisite for appeal. That didn't happen here, and I think that's particularly problematic because we have this assertion that, well, even though there were findings, because the words strictly necessary aren't in there, we don't know if the court actually thought about these other things, even though those findings are clearly baked into the district court's order. Excuse me.
I do think that's one of the tricky things sometimes with the preservation situation. You know, if you ask the court to rule on strictly necessary, the court doesn't expressly do so. It's preserved, you asked him to do it, but at the same time, it seems like it'd be much more, this is my PSA announcement, much more efficient for everyone involved to just say to the court, we need a ruling on this, right? The court should have done it one way or the other, said whether he thought it applied or he didn't. But it would be helpful if people would just ask before we end up here a couple years later, you know, especially in cases like this, just so that we don't end up having to prolong anything unnecessarily.
Well, and I think, Your Honor, to that point, there is already sort of a rule that captures both sides of that coin, which is the general rule is if you present it to the district court, you've given it the opportunity to rule on it. But here, we think the district court did rule on it in terms of he's made sufficient findings to determine that it was strictly necessary to terminate the parental rights. And if appellant's position is that those findings are legally insufficient because it doesn't say the word strictly necessary or it's missing X, Y, or Z finding, then those are the things that you do need to bring to the court's attention for preservation purposes. So I'm not suggesting that strictly necessary as a concept wasn't presented to the district court.
Sure.
It's just that their argument on appeal about the notion that the findings as they sit are insufficient, that I think is one of the few scenarios where there's an express carve out that you do need to present it to the district court for exactly this reason, because frankly, I don't think on this record there's a meaningful argument that if we are going back down to the district court that it's going to do anything different than say it's strictly necessary, I meant what I said, the parents' rights are still terminated, you've made no showing that this is a functional possibility because of the whole entire history of these proceedings. And this is where I think looking to INRI AH and INRI DS is particularly instructive for the court, because INRI AH says the fact that we have a kinship placement and that there's a permanent custody and guardianship option available doesn't mean that strictly necessary, that doesn't mean that termination isn't strictly necessary. It means that you have that option on the table, but here we've considered it. And the court the Court of Appeals in INRI AH was distinguishing, saying that INRI AH's factual scenario was more severe or more warranted termination than, for example, the Court of Appeals opinion in INRI DS. But then this court reversed in INRI DS and said even in that scenario, the termination was necessary because it was strictly necessary because the best interests of the children were not served by maintaining the residual parental rights. And here we've got a scenario that's certainly much more severe than I would argue DS and probably also HH, which is not just that we're concerned about any sort of lingering involvement of the parents in the children's lives. It's the nature of that involvement is disruptive, detrimental, harmful. We have unchallenged findings that father abused the children. He tried to, I don't know that he was trying to kill anyone, but I think firing a gun at a child is certainly a danger to the child. There's been no mention of that finding in appellant's briefing. There's been no challenge to any of the grounds for termination. And those grounds are of the nature where it does, as the district court found, present a threat of danger to the children.
What is your best argument on the strictly necessary not applying here? So you made a few arguments in the brief. The thing that's hard for me is just that kind of the introductory language in the Adoption Act that seems to include, it doesn't list a specific subsection with grounds, it just includes all of 80, Chapter 4. And so it does seem to be cross-referencing everything that is kind of related to grounds at a minimum. And so it's hard to say, but it can't mean that. It can't mean the strictly necessary when it seems to be cross-referencing it. So what's your best argument that it doesn't?
I think there's kind of two pieces to that. The language of the Adoption Act says that it references the grounds described in the Termination Act. It doesn't reference just terminated under Section X of the Termination Act. It's on the grounds described in that act. And the best interest portion, the Adoption Act goes on to say that it's terminated under those grounds and in the best interest of the child.
Yeah.
So it's not that we are actually incorporating the entirety of that provision, it's that it's the grounds in that provision. And I think that the analytical framework that Appellant's Counsel was talking about in BTV is, the court rejects an analytical framework that puts strictly necessary in the grounds bucket. And I think that's significant. The analytical framework is that strictly necessary is part of the best interest analysis. It's not part of the grounds. We don't have language in the Adoption Act that says terminated under the Termination Act, the entirety of that section, or terminated under the grounds and best interest as described in this section. It's the grounds. And I'm sorry.
One thing that seems to sort of go in your favor is that in the Adoption Act, it says, if we look at 8113-202, which seems to be, it's similar to in the Adoption Act, section 104, where they talk about kind of legislative findings and what's a compelling interest. In the Adoption Act in 13202, it says, in every adoption of a minor child, the best interest of the minor child should govern and be a foremost concern in a court's determination. But then in the Termination Act, we have in 104, it's under 104.12a, wherever possible, family life should be strengthened and preserved, but if a parent is found by reason of the parent's conduct, et cetera, to be unfit or incompetent, then the juvenile court shall then consider the welfare and best interest of the child of paramount importance. And so it seems like in the Termination Act, there is this sort of sequencing where the parent's rights get like they're sort of in first place for a while until there's a finding of grounds, and then it moves to the child's best interests. But the Adoption Act is saying up front the best interest of the child is the first concern, and I'm just not sure how I think that if we are looking at the Adoption Act and how it sweeps in all of 80-4, it would also sweep in section 104, but those seem to be in conflict a little bit to me.
I think the difference in the purposes between the acts is actually part of what makes this distinction so important, what makes the distinction in the language so important. I think it explains the distinction in the language to an extent, is that the function and the purpose of the Termination Act is effectively to ensure the children's safety, right? The point of a termination petition initiated in the juvenile court under the Termination Act is that we have some concerns for the children's safety. There's a lot of ways to deal with that short of terminating parental rights. There are many arrangements you can come up with that handle safety concerns for children short of terminating parental rights, and often that includes restoring parental rights or putting parents on the path to overcome the grounds that they have that warranted DCFS interference in the first place. By contrast, you look at the Adoption Act, and the entire purpose of the Adoption Act is to facilitate an adoption. Those acts have different purposes, and the difference in the procedure and the statutory language facilitates those precisely different purposes. If a petition filed under the Adoption Act is always going to have someone who is ready, willing, and able to come take over the parental role for those kids. That is not the case for every petition filed under the Termination Act. And the difference in those purposes is really the thing that underlies why we treat these scenarios differently. And I also want to point out that the court's explanation of sort of the role of the best interest analysis is not just, it's important to look at what the court views as that giving parents an opportunity to set forth. The court says that a best interest analysis, this is in BTB, the Court of Appeals opinion in BTB, that the best interest analysis is where the parents can demonstrate that they have been recently engaged in significant efforts to improve their lives and remedy their past issues. Certainly, that opportunity was given to the parents here, and they clearly failed to demonstrate any sort of improvements to improve, or any sort of efforts to improve their lives or remedy past issues, let alone any significant efforts to do so. And this court's opinion in BTB indicates that the court can terminate parental rights only when it concludes that a different option is in the child's best interest and that termination is necessary to facilitate that option. If the child can be equally protected and benefited by an option other than termination, termination isn't necessary. We have the court's determination on that point here. The court finds that a different option, adoption, is in the child's best interest and termination is necessary for an adoption. Those two cannot coexist. And the child cannot be equally protected and benefited by a different option such as permanent custody and guardianship because, again, we've tried that. It didn't work. Not only are the children not equally protected by that, they are certainly not benefited by it. They are certainly not benefited by the parents' ongoing contact or even absence of contact leading to further disruption and trauma of being absent from the children's lives on their own volition.
Counsel, just speaking in the abstract, what would you say qualifies as a ground? How would you define a ground?
I would point to the list articulated in the Termination Act.
It's in the abstract.
Just in the
A ground for a decision.
A basis for why the parent is not able to continue in that role.
And so, in that sense, why would not a finding of strictly necessary be a ground that must be established for parental rights to be terminated?
I think the distinction that the court makes in BTB is sort of the best answer to that, which is that the grounds are just what sort of give the court the ability to take a look at this in the first place. And you can have those grounds at the outset, but parents can make progress to address those grounds, in which case it may not be strictly necessary to terminate. But those are distinct, those come apart, because the fact that it can't be strictly necessary to terminate the parental rights in the abstract of some concern, right? Or one of these grounds, one of the bases for the court's involvement. Those come apart because the parent has either addressed or has not addressed the concerns that gave rise to DCFS involvement in the first place, or in rare cases, private petitions in the first place. But
301 doesn't reference grounds. We infer that these are grounds. It provides that if the juvenile court finds the findings.
So which provision are you referring to?
Section 301(1), Termination Act, the prefatory language.
Right.
May terminate all parental rights with respect to the parent if the juvenile court finds, and then lists things the court must find. And your point is that a strictly necessary finding is an altogether different finding, maybe a threshold finding. How conceptually would you?
I think conceptually that's reversed, so that the grounds are the threshold finding and strictly necessary. So you can have grounds and it not be strictly necessary, but they're not. They do come apart, and that's why the strictly necessary analysis is part of the best interest analysis rather than the grounds. But again, I think that's here, at least, that's baked into the court's best interest analysis regardless, is we know exactly why the best interest of the children is served by staying with the grandparents. The best interest of the children cannot be served by having parents' involvement still. And I also, just in talking about grounds, do want to point back to we do also have an alternative grounds to affirm, which is that the parents, there's unchallenged findings that the parents both abandoned the children. And to be clear, we acknowledge the difference between the definition of abandonment under the Termination Act and Adoption Act. That's on page 4 of our brief. There's a different particular definition of abandonment under the Adoption Act, but the district court's finding of abandonment under the Termination Act is overlapping with the necessary findings for implied consent under the Adoption Act. And implied consent means when there is implied consent, it cannot be withdrawn, and there is no need to even conduct a best interest analysis. So if strictly necessary could be deemed required as part of the analysis, it is in the district court's order. There has been no showing that anything is missing from that order or that any additional findings would change the outcome. And even if that were not true, there is an alternative grounds to affirm that obviates any best interest analysis whatsoever. If this court has no further questions, we'll sit on the briefs.
Hey, Ms. Webb.
I do have one question, Ms. Webb. Can you hear me?
Yes, sorry.
That's all right. That's all right. So you say that the state, or DCFS basically, generally files under the termination statute, but private parties can do that too, right?
They can.
So why should the standard basically turn on the filer's choice of venue?
Well, I think the difference in purposes is sort of, again, the instructive piece here, which is that if a private party is initiating a petition in the juvenile court, the purpose of that is not obviously to facilitate an adoption, because if they were intending to facilitate an adoption, they would go to the district court and file under the Adoption Act. So the purpose, again, of a private party or the state initiating termination proceedings under the Termination Act is a concern for the safety of the children, which again can be accomplished in ways short of termination, and in that circumstance, there's not necessarily someone who is volunteering themselves to take that role over from the parents. They're just acknowledging that there is a serious concern that needs to be addressed. But the inverse of that is obviously true when you're filing under the Adoption Act, because the purpose of that proceeding is that we are facilitating an adoption. And the legislature has articulated different standards for both of those, and has articulated different purposes and even constitutional concerns under the Termination Act versus the Adoption Act, whereas the Termination Act is to facilitate, primarily, obviously, the safety of the children, but that emphasizes the role of the parents in that safety. But the Adoption Act's purpose is to facilitate adoptions and to ensure that the children's interest in being in a stable adoptive placement and the adoptive parents' interest in a final adoption placement is met. So they have fundamentally different purposes that warrant different standards. But again, even if that were not the case, those standards are met regardless of which standard we're operating under.
Thank you.
Thank you, Ms. Webb. Ms. Adams?
Thank you, Your Honors. Just briefly, I need to correct something I said before to Justice Pullman. Justice Pullman, you asked about a protective order and whether it was going until 2029. According to Exhibit 43, it expired in May of 2024. So I just need to correct that factual comment. The Termination Act, going to Justice Peterson's questions about the purposes of both of the acts, the purpose of the Termination Act is, it's about how and when do we terminate fundamental parental rights. But really, the Adoption Act is slightly different. It's all about the stability of the adoption. So when we're talking about when and how do we terminate fundamental parental rights, that's more of a Termination Act question. And when we're talking about, how can we make sure that this adoption sticks, that's an Adoption Act question. So you can read these two statutes in harmony. They're not in conflict with each other. They're not fighting each other. They're just answering different questions. Also, most of the Adoption Act adoptions are done through consent-based adoptions. It's either through a voluntary relinquishment or something like that. And so that is why the Adoption Act focuses on the new parent-child relationship rather than terminating an existing parent-child relationship. Under no circumstances, as Justice Nielsen was mentioning, under no circumstances should it be easier to terminate under the Adoption Act, because as this court has already held in BTB, in private adoptions, there has been no services, there are very few protections, and the best interest inquiry is often the most important and the first time that a court can consider whether this termination should actually occur. When it comes to the implied consent, we have briefed that pretty thoroughly, but just to note that it simply isn't apparent on the record that the court made findings about either abandonment or that the parents didn't communicate with the children for more than 180 consecutive days. Abandonment is defined in the implied consent statute as abandonment around the time of birth, and that certainly didn't happen here. And then right here, for not communicating with the children for 180 consecutive days, we actually have evidence, well, the court made a finding that mother calls once a month or once every other month. That's on page 678 of the record. And so there's not apparent on the record that mother has not had contact. And then with father, we certainly have had this protective order that's been a problem, but father in 2022 got full custody of the children. So certainly he has acted in a way where he's trying to maintain a substantial relationship with the children.
Since 2024, since that protective order expired? What's he done?
So we don't have any evidence from 2024, but
Okay.
a lot of the evidence that the appellees were citing was before father had gotten custody of the kids through that divorce court order. Father has
Okay.
acted in a way where he's wanted to have a substantial relationship with the children.
Got it. And was this trial before that expired? Was it still in place when the trial occurred?
I believe so. The trial, I believe, is in 2023.
Okay, so maybe that's why there's no evidence of
Yes.
post-conduct.
Yes, I believe. You know what? It's not on my timeline, but I believe the trial was in 2023.
Okay.
This case is rather old. So, unless this court has any other questions, we'd ask that this course reverse and remand for a best interest finding. Thank you.
Thank you, counsel. Thank you, both counsel. We appreciate the excellent advocacy in this case, and we'll take it under advisement.